Namaste and welcome to Dear Society. In today's video, I will be explaining in detail what a builder or promoter needs to do when a project cannot be completed within the original time and even after the extension granted under Section 6 of RERA Act. We will go step by step through current applicable procedure under Section 7 subsection 3 of RERA Act based on the latest binding directions issued by RERA. As per Section 7 subsection 3 of RERA Act, RERA may, in the interest of allottees, allow a project registration to remain in force even beyond maximum permitted period if promoter shows sufficient cause. But this is not an automatic extension. The promoter must follow a specific application process supported by documents, declaration and updated plans. Let's now go through the exact steps that a builder or a promoter must take today if they want to legally apply for such an extension. Earlier, as per RERA, a required association of allottees to pass a resolution by 51% or more supporting the same promoter for completing the project. That consent route still exists. However, many projects were stuck because of promoter could not get the majority consent in writing. To resolve this, RERA issued few more orders allowing the promoter to apply for an extension even without 51% consent, provided they submit a detailed and justified application. This is the currently applicable rule. The promoter must submit the extension request using Form E as prescribed under Rule 7.1 of RERA rules. This is formal application form for extension of project registration. Along with Form E, the promoter must pay the applicable extension fee as specified under RERA rules. This fee is mandatory whether or not the 51% consent is available. If the promoter has collected any consent letter from home buyers or the association of apartment, they must be submitted in Form B. If 51% consent is not available, it is still necessary to provide whatever support has been collected. If 51% could not be obtained, the promoter must submit a letter on company letterhead explaining why the required consent could not be gathered, what steps were taken to try and get it, why the project extension is still in the interest of the allottees, and why RERA should consider the application despite shortfall in consent. This explanation must be honest, detailed and factual. The promoter must also submit an explanatory note showing the exact reason for project delay, documents supporting those reasons and a revised completion plan, preferably in the form of PERT chart or construction schedule. This is crucial. RERA wants to see a realistic plan, not just promises. Additionally, promoters must also disclose all pending complaints or litigations related to the project. This includes complaints pending before RERA, the RERA Appellate Tribunal, Consumer Forum, Civil Court, NCLT or High Court. Detail of the case includes case number, status and any interim order must be attached. Promoters must submit a notarized declaration confirming that the extension will not affect or limit the rights of the allottees. That promoters agrees to comply with all conditions RERA may impose. That the decision of RERA shall be final and binding. This declaration is a legal undertaking. It protects the allottees' interests. The promoters must also ensure that the project information on the RERA portal is fully updated. This includes sale and booking status, various forms, revised timeline for delivery, parking and amenity disclosures, upload of revised formats wherever applicable. Outdated or incomplete disclosure can lead to rejection of the extension application. After all documents are submitted, the promoter must wait for RERA's decision. RERA will verify the justification, documents and risk to allottees before granting or rejecting the extension. There is no automatic extension. Even after full application, RERA has full discretion to approve, reject or modify the request. So my message to all promoters is this: if your project is delayed, do not hide. Face the situation legally, transparently and responsibly. Prepare your documents honestly. Do not manipulate consents. Treat your allottees with respect. They are your partners, not obstacles. And remember, RERA will support completion, but not at the cost of buyers' rights. This was a detailed guide for builders and promoters on how to apply for extension of project registration under section 7 subsection 3 as per the latest RERA framework. If you find this useful, please share it with developers, architects, project consultants, or society office bearers who need this clarity. For more such legal updates, stay connected with Dear Society, because clarity builds trust.